You might be. Good morning, everyone, and welcome to the Committee on Commerce. Happy to open today's hearings. We have a lot of folks who are going to be cycling in and out, so don't think we're being rude, but they're headed over to Granite Place to present bills to House committees. So that will be taking place. It'll be musical chairs of sorts up here today. But I'm going to go ahead and open the hearing on House Bill 1197 and welcome with a good morning, Representative Hunt. Mr. Chairman, good to see you.
Thank you, Mr. Chairman. For the record, I am John Hunt, representing Ringe, New Hampshire for 20th, this is my 20th term. So I bring to you the department, Insurance Department's technical corrections, as you probably have experienced over the years, that it's a very big statute and it has a lot of moving parts, and it's time to update each one. My preference is that we'd invite them up and have them walk you through it if you have any particular questions.
Okay.
Unless there's something you guys have already that you're just dying to want to ask me.
All right, seeing none, thank you, Representative. Appreciate you being here. And the Insurance Department is here. We have DJ Betancourt and Josh Hilliard. Good morning, gentlemen.
Good morning, Mr. Chairman, members of the committee. Nice to see you all. Some of you will see me a few times today. I'm sorry about that. But for the record, my name is DJ Betancourt. I have the pleasure of serving as the Commissioner of the New Hampshire Insurance Department. I'm joined here at the table by Josh Hilliard, who is our Enforcement Counsel. So as Representative Hunt mentioned, each year the department brings forward a piece of technical legislation that attempts to clean up the statutes or to ensure that the statutes are finely tuned to address the issues that were contemplated under the statute, but circumstances have changed or things have evolved such that we need to update how we approach certain things. There are two predominant provisions of the bill that I want to highlight for you. The first is with regard to how we are dealing with enforcement actions. And it's a very practical situation that we are confronting, which is we have a lot of producers, so those are agents and brokers, who are doing things that they can't do. Now, let me preface this by saying that rarely do we see this with agents and brokers who are here in New Hampshire. Where we do see it are those producers who are located elsewhere but have a license to sell insurance in the state. We're seeing this particular problem, and I won't mention any states in particular, but it's Florida, where we have producers who are engaged in all sorts of interesting things and who are in the process of doing those things are harming New Hampshire consumers. So what happens at that point when we become aware of what's going on is Josh and his team will swing into action and they will attempt to make contact with the producer to find out what's going on. And in the nomenclature of our time, what they are finding is that these producers are ghosting them. They're not getting back to them at all in many cases, or they're very, very late in responding to the department's inquiry, which inhibits our ability to investigate what's going on. But ultimately, we're trying to bring restitution and get the right result for the consumer at the end of the day. So our statute as it currently stands is there is a fine of $2,500 for this non-responsiveness of the producer. That amount was set in the early 70s. I want to say in 1971. It has not been updated since. We did the math. If you were to try to update that number from 1971 to today, it would be approximately $20,000. We thought that was a bit radical. We thought that that would be a pretty significant bump, and we didn't want to do that. So instead what we did is we raised the fine to $5,000 in the hopes that that would grab the attention of that producer a little bit more firmly. But what we also did is our current process when we're going to suspend a producer's license, there's a whole process that's involved with that. And unfortunately, when, again, we're dealing with out-of-state producers, they don't answer, much less show up for a hearing to present their case as to why their license shouldn't be suspended or revoked. So what we're trying to do here is to shorten that process or take some parts of that process out as a mere efficiency, because we're taking a lot of time and resources to go through this full process knowing full well we're never going to see this person. So that is provision number one. And I would say that that was actually something that we worked with industry on and came to a compromise on, because when we first brought this proposal forward, what we had said was keep the $2,500 fine, but we're going to apply it to each and every day that that individual is not in compliance. And industry understandably pushed back and said, well, there are some unintended consequences of that. We want to make sure that we're actually rightly treating or punishing the individuals who deserve to be punished, and not having a situation where somebody's getting a gigantic fine over the course of a 10-day non-compliance because the person was in the hospital, on vacation, something of that nature that's completely understandable and explainable. So this ultimately was the compromise that we reached. The second predominant provision of the bill that I want to discuss with you is, again, with producers. So when a producer applies for a license, they have to go through the exam and all of that. But there is as part of that process, they have to disclose whether or not there are criminal convictions in their background. Currently, what the statute says is they have to disclose, and it comes to my attention to evaluate the situation when there's been a felony level offense. Within the last year or two, we have come up against some pretty troubling situations where individuals have applied for a license. They've done some very, very concerning things. And because they've had good attorneys or because the court's docket was full, they were successful in pleading those offenses down to misdemeanors. And at that point, I don't have discretion to look at the situation and ultimately make the determination whether or not the individual should be selling insurance in this state. The most glaring story that I'll share with you, again, about a year or so ago, individual, significant mental health challenges. Obviously not something we're going to hold against him. The trouble was he decided to stop taking his medications for it. He subsequently became homeless. He was living in a campground and was caught stealing ladies' undergarments from their tents and campers, and then was caught trying to install cameras in the ladies' room bathroom. Needless to say, I, as commissioner, would not feel comfortable having this individual making house visits, selling insurance with women in the home. However, because of where the statute stands today, in one of the most distasteful decisions I've been forced to make, we had to grant that individual a license because he had pled it down to a misdemeanor for whatever reason. And I said, that has got to change. Now, I will tell you how I assess these types of situations, whether it's a felony or whether it would be a misdemeanor. I look at the time that has lapsed since the conduct was done. I see or look for what the individual has done to turn their lives around, to make restitution in the event of a financial crime to the victims. I look at all of that. And in my tenure as commissioner, I have granted licenses to felons. Now, those felony convictions were decades in the past, and again, we had mountains of references from people who attested to the fact that the individual, as they are applying to us today, is not the individual who was doing those acts, which, by the way, for those of you who are attorneys, it is the same standard that the Bar Association applies when a disbarred attorney is reapplying for admittance to the bar again, that they are no longer the same person today that they were when they committed the offenses. So that's the analysis that I, as commissioner, run through. And what I'm asking for through this piece of legislation is the same flexibility when we're looking at misdemeanor level offenses. The only other small provision that I would just draw your attention to is on the last page, two things actually on the last page. The first is on page 12, line 4, you'll see a new sentence there, or half sentence, that says, except for standalone group dental coverage and standalone group vision. There are new products that are coming on the market that are seeking to complement or supplement more comprehensive plans that are currently on the market. Our statutes don't have the ability to give us flexibility, if that makes sense. Let me start that over. We don't have the flexibility currently to approve these products or to go through the analysis that we typically go through for these new types of products that deal with just standalone dental coverage and standalone group vision. We would like that flexibility. We would like consumers to have greater choice, access to greater choice in the market. And so we're updating our statute to give us that flexibility. And the last piece there is truly a cleanup piece. When we did our CCRC rewrite, so that's continuing care retirement communities, it's an oddity. I think that at some point when these entities came online, people sitting in your seats didn't know what to do with them exactly, so we ended up getting the oversight of them. But they are retirement communities for wealthier individuals. They are very soup to nuts type of facilities. You can get direct in-home care, you can get memory care, all of that stuff. It's really a one-stop shop right where the individual lives, and they can live the remainder of their lives in those facilities. They pay very large fees to get on the waiting list, and they pay very large fees to reserve their spot. We were finding and dealt with some very difficult situations where the CCRCs were in financial trouble. Some of them were on the brink of insolvency, of bankruptcy, and wrapped up in all of that are those large sums of money that these individuals had put forward to reserve their spot and to get on the waiting list and all of that. And despite the fact that it's catered towards wealthier individuals, for some of those individuals, those monies represent a significant portion of their life savings, of their retirement security. So we brought a big comprehensive reform forward last year to have greater oversight over ensuring that they're staying financially solvent. What was happening concurrently as that bill was going forward, you all were making some changes to the homestead exemption. So we needed to account for that change in the homestead exemption to line it up with what we were doing with the CCRCs. So that is the last piece that you see there. Okay. So I don't think I've missed any of the particular provisions, but Josh and I are, of course, happy to answer any questions.
All right. Are there any questions? I think you covered it.
Thank you, Mr.
All
Chairman.
right. Thank you both. Is there anyone else who would like to speak on House Bill 1197? Hearing none, we will close the hearing on 1197 and very shortly open on 1262. Oh boy. Okay. All right, we're going to open the hearing on House Bill 1262. And I would like to invite Representative Lucas, correct, to come join us, please.
Good morning, Mr.
Good morning.
Chairman, committee members. Thank you for the opportunity to testify this morning. For the record, I'm Janet Lucas, representing Grafton County District 7, and that includes Campton and the Waterville Village Estates District. The purpose of this bill relative to home heating oil and propane contracts and sales is to address some serious unresolved issues that continue to cause loss of power, property damage, and resulting large expenses for property owners who signed contracts and trusted they would be fulfilled. The bill has been strengthened and renamed by House Commerce and Consumer Affairs Chairman John Hunt's amendment, which I support wholeheartedly. I'm sending around 2 photos in the packet with my written testimony. I have permission to share these photos from the property owner. In the first, you see the results of a failed propane delivery, frozen pipes, flooding, and structural damage. In the second photo, you can see the contractor had to break through a wall of ice to expose the empty propane tanks. Another item in the packet is a newspaper article that includes interviews with folks and what they experienced when their heating oil or propane delivery was too late. Failure to deliver heating oil to households that shelter seniors, the very young, and anyone who depends on a life-sustaining medical device is dangerous and unfair business practice, but is also potentially life-threatening. Folks who live full-time in New Hampshire should not have to maintain a second home or have access to a place of refuge as a condition for choosing to live here. I know there are a lot of folks who want to speak to this bill, so I think I'll give them that opportunity.
Okay.
Thank you.
Representative. Appreciate it very much. The Attorney General's office, Mary Stewart, is here. Good morning. And
Morning. And Alexandra Sosnowski, who's also from the Attorney General's office, is just here with me today.
okay.
This is our propane division at the Attorney General's office.
Okay.
My name is Mary Stewart, and I am an Assistant Attorney General with the Consumer Protection and Antitrust Bureau at the Attorney General's office. I'm here to express the Attorney General's support of this legislation. This heating season, which we define as October of 2025 to present, it's snowing today, the Attorney General's office received 171 contacts from New Hampshire consumers regarding their propane company. Contacts defined as a hotline call, we have a hotline, or a formal complaint. These calls deal with a number of issues, predominantly delayed deliveries, unexpected fees and costs associated with delivery and service, the difficulty and cost of terminating service, and propane companies' failure to remove their tanks once they do terminate service. So the sections 6, 8, 9, and 10 of this bill that's in front of you, those proposed sections, deal with these issues. Propane is considered to be a competitive industry. It's not regulated. It's not a regulated utility, so it's not governed by the PUC. A key to a competitive industry is transparency of price and product. And the consumer must be able to understand the product they're buying, the price they're paying, and should be able to move freely from one provider to the next. That would be a competitive market. And transparency is not just price per gallon, because one company may charge, $2.33 price per gallon, but they also have a number of fees, costs associated with each delivery. So the actual cost per gallon could be much higher. And another company that has, doesn't charge all those fees and costs may have a higher price per gallon, but it could theoretically be cheaper. So section 10 of this bill particularly deals with disclosures of fees and costs, so that when a consumer enters into a contract with a propane company, that they understand how much they are actually paying for the service. The other provisions, the section 6 talks about time restrictions for propane tank removal. Section 8 talks about rental fees if the propane company doesn't own the tank, which seems self-obvious. 9 talks about required refunds for fuel and tank when service is terminated. So one of the problems we've seen is when a consumer will terminate a service and the propane company comes and takes the tank, they don't necessarily refund the consumer for the fuel that's in the tank. And that fuel, if it was paid for by the consumer, is owned by the consumer. So this bill would require them to do that. And again, 10 talks about disclosures of fees. We also put in a provision there regarding tank removal fees. One of the problems that we have seen is that when a consumer cancels service, they encounter a number of fees associated with canceling service. Tank removal fee, $199, termination of contract, $100. They don't get the propane that's back in their tank, and then a service fee or whatever other fees are associated with that. So it can cost several $100s just to cancel your propane service, and that inhibits free competition. It makes it hard for a consumer to move from one provider to the next. And so we added that in. And I will say that all of the provisions, except for the emergency delivery provision, which I'm going to talk about in a second, were all derived from either the Vermont statute or the Connecticut statute, which are currently in effect. Both Vermont and Connecticut have comprehensive propane legislation. And so we just drew from their language because it's working there. So we figured that would be the easiest transition here. And we have spoken to the propane industry over the past month since the House bill was amended. And I think largely they don't object to those parts of the statute. The part of the statute that they do object to is the emergency delivery provision. So just as I talk about that, so what I want to talk about what our calls that we received. We received, like I said, 171 contacts from consumers in the Consumer Protection Bureau this year. Of those calls, 49 of them were out of fuel calls, out of fuel. And I will say an out of fuel call, not in every case where a consumer reports they're out of fuel, are they in fact out of fuel. But I also know that we have talked to these consumers who have subsequently received a delivery, and the propane company has said, well, they had fuel in their tank, and the consumer counters, well, I may have had some fuel in my tank, but my furnace stopped working because apparently there wasn't enough fuel or however that works, so the furnace stopped. So I consider that an out of fuel call. So maybe not all of those 49 customers were out of fuel, but something happened to make them think they were out of fuel. In addition to that, and I do have a list of all of our complaints that I can hand you, but in addition to that, there are another 30 to 35 consumers who had essentially under 20% fuel in their tank when they started calling the Attorney General's office. And I think it's important to know that, when a consumer is at 20%, the first thing that hits their mind is not, I'm going to call the Attorney General's office. They call their company, which is exactly what they should do. And the company, what we have found, often will say, with these complaints, I should say, we're going to be there in 5 days, and then they don't show up in 5 days, and they call again, and we'll be there in 3 days, and they don't show up in 3 days, and the consumer calls again, we'll be there tomorrow, and they don't show up tomorrow. And then the consumer starts to panic, and they call the Attorney General's office. So, and those people often, even though they are not out of fuel, may turn their heat down to 55. They're going out to buy like electric heaters. They're stop taking hot showers. They may not cook their food on their stove. I mean, they start taking behavioral changes to make sure they don't run out of heat because of all the consequences that happen when you run out of heat in January, in November, in New Hampshire. So that's the premise of why we wanted to do this emergency delivery provision. So what does it say? What that provision says that if a consumer calls and they have less than 25 gallons in their tank, the provider must either deliver fuel within 5 days or within 24 hours notify the consumer that they have more than 25 gallons in their tank and that this provision doesn't click in, or that they release the consumer, provide a written authorization so the consumer can get a propane delivery from a different company. So one thing about propane is even though, the tank is on your property, the tank is often owned by the provider, not by the consumer. And there is a New Hampshire propane law, container law, that says if the propane tank is owned, whoever owns the propane tank, nobody else can deliver fuel in that tank unless they have written permission from the owner of the tank. So this statute requires, if there's 25 gallons that is verified by the company or less in the tank, and the company cannot deliver within 5 days, so that person does not run out of fuel, then the propane company has to, they can now, but they don't. Under this statute, they would have to provide written authorization for someone else to fill the tank. That's what this provision says. So what are the objections? What are the objections that I have heard? One is, first was the safety objection, which is obviously of great concern to us. So we did contact the fire marshal, Sean Toomey, who is not able to be here today because he's sick. But we talked to him about it, and he didn't see any problems with it. And there was a couple other people on the call as well. So we don't think that there really is a safety concern. There's nothing in this bill that prevents the company B that's coming in to put the fuel in. They could do their own safety check. They could do whatever they need to do in order to put fuel in that tank. So as long as, and there are plenty of regulations about that are obviously still in effect. This doesn't change anything. So that would still happen. The other concern we've heard is, well, nobody's going to do this. Nobody will do it. They won't fill another person's tank. And I don't know if that's true or not, but I do know that if they don't do it now, and if we don't provide an opportunity for them to fill the tank, they definitely won't do it. So I don't really, if nobody does it, it's almost like no harm, no foul, then we'll rethink the problem. And then the other concern I've also heard is that the propane companies are concerned that they're going to get inundated with consumer calls of people who aren't really under 25 gallons or less. And then they will have to deal with those calls during the heating season, and they have a lot to deal with during that time as well. So I reiterate that the Consumer Protection Division received 171 calls. So I would suggest that the propane companies are better situated to handle these calls than Alexandra and myself, because we are not designed to be customer service for propane companies. That's not what our office does. And that's what we've had to do this winter. And I will say, we've received so many calls that because it can be a life or death situation, we have special protocols for these type of calls. And essentially people have to drop everything to make sure that if there's something that needs to be done, if somebody is without heat in January, something needs to happen. And that's really what's at stake here with this stuff. And then the last thing that the complaint that we have heard, or the concern we have heard from the propane industry, is that the Attorney General should deal specifically with the companies that are causing the problems. And like I said, I do have a list that I can hand you of all the calls that we have received. And you will see when you look at that is that the most of the calls, except for maybe a handful, are with 4 companies. It's AmeriGas, Superior Plus Propane, Suburban, and Irving. Those are the 4 largest companies in the state. And I cannot comment on ongoing investigations, but I can tell you that as with every complaint that we receive in our office, we look at every complaint closely, and if we believe there's a violation, an unfair or deceptive act or practice, we do an investigation and we will pursue enforcement action as necessary. That doesn't happen overnight. What this emergency delivery provision seeks to do is help the consumer today, when their heat is out today. It doesn't help them if we pursue an enforcement action that resolves in a year or 2 years. That doesn't help the consumer that's sitting in a cold house in January in New Hampshire, and that's what this seeks to do. And the other thing I want to say too about these calls is even though there are 4 companies that are on, that we are receiving the complaints for, those 4 companies service a majority of New Hampshire consumer propane customers for primary heat. The industry, if you look into the industry, you will see that it has been consolidating in the past 25 years, and the trade magazines and various organizations indicate that that trend will likely continue over the course of time. So next year, maybe this year it's 4 large companies, maybe next year there'll be 5. So what we're seeking to do is through this legislation, when Chairman Hunt asked us to draft something, this is what we came up with, because we thought it would help encourage the competitive nature of the business and address some of these immediate problems that we were having. So I'm happy to take any questions or talk further about anything.
Senator Shardy.
Thank you, Mr. Chair. Thank you for taking my question. You partially answered my question, which was going to be, out of the 171 complaints, is it a reoccurring theme with certain companies? Because I can tell you, I've had Palmer Gas for 40 years here in New Hampshire, never had an issue. Now you've indicated that there are 4 companies. So one of my questions is, correct me if I'm wrong, are those companies not located in New Hampshire? Those 4 that you're getting the complaint?
They're not headquartered in New Hampshire.
See.
No.
And my other question, follow up?
Yes, of course.
My other question would be, what in this provisions that you're providing to us today, if a consumer hasn't paid their bill, and let's say they owe the propane company $1,000, they would probably feel very hesitant to be forced to go and deliver another tank full of $1,000. Is there anything in this bill for that?
So, no. Is there anything in the bill? So if somebody owes money, I think it's important to understand that the complaints we have are not what they're not. And they're not about people who haven't paid their bills. That's not what we're trying to address. If somebody hasn't paid their bill and the propane company has terminated service, there's nothing in this bill that would force them to provide propane for somebody that they've essentially if they've locked their tank. I mean, there's propane in their tank. If they haven't paid their bill, the propane company is going to lock their tank. So they're going to have more than 25 gallons in their tank. So it's not really going to it doesn't really affect that group of people. The people that have filed complaints in our office, the first thing we ask them are you current on your bill? And if you're not current on your bill, we try to get them to people who can help with that, the various heating resources. The other thing we ask people is, are you a will call customer? That's something that the propane company will say, well, maybe they're will call customers and they called us too late. Nope, these aren't will call customers. These are automatic delivery customers. They are prepaid customers who have done nothing. that they're just living their life, getting propane delivery just like they always have, paid their bill when they get their bill or they prepaid it, and they don't get their fuel delivery for reasons they don't know. And something the other propane company will also say is, well, maybe they changed their use. Maybe they had somebody move in the house, and so they're using more heat than they did before, or maybe they got a propane stove. I mean, that may be true, but that doesn't justify running out of fuel.
Thank you.
Senator Reed.
Thank you, Mr. Chair, and thank you for taking my question. So it sounds like there are 4 large players that, and I'll be interested to see your list of complaints to see what the proportion of that is. How many propane delivery companies do we have in the state of New Hampshire?
My understanding is there are about 35 or so. There may, and I'm sure the propane association will tell you exactly, but it's about 35 propane companies. Predominantly smaller, not smallish or smaller than these companies, but these are large regional players that have come into the state.
Follow, if I might. So just to continue on where Senator Ricciardi was just asking about, she's never had an issue with her propane company for all the years she's doing, and we'll see on the list there if that's true. Are we unduly burdening a whole lot of little guys that are doing it just right because we have 4 out-of-state bad actors?
Well, and that's a great question, but it seems to me if this is a competitive industry, which it says it is, all that most of these provisions do, 6, 8, 9, and 10, all they talk about is you have to tell consumers what your price is. You can't make it hard for consumers to leave your company. You can't charge them excess fees. I don't know, but we haven't received complaints about these smaller companies. My guess is A, they either probably already do that, or B, they don't charge fees to let people in. Those aren't the ones that are going to be affected. They're probably doing all of this anyway. So I don't think it's a burden on them. And in fact, in a way, by requiring this, could potentially help them. So consumers will have more knowledge about the deal that they're getting into with these larger propane companies.
Thank you.
Okay. All right, thank you for your testimony, appreciate it.
Can I just give this?
All right, we have Bob Scully and Leslie Anderson here from the Propane and Gas Association of New England. Good morning, gentle people.
Good morning. Thank you, Mr. Chairman, members of the committee. For the record, my name is Bob Scully, representing PGAN, which is Propane Gas Association of New England. I would just like to give a quick overview of where we are today, and then Ms. Anderson here will speak to the points that we are uncomfortable with. We are opposing House Bill 1262 as it is written, and we'll support a draft amendment if it comes up. And I just want to put a little perspective in what we have here in New Hampshire. So there are 59 propane dealers in the state of New Hampshire. 4 of them are the large national providers that were talked about earlier. When you look at the list that the Attorney General's office distributed to you, the complaints are all on those 4 companies, okay? The remaining 55 companies, at least when I saw the list in their office, there was 0 complaints filed. To put in perspective, 171 complaints and then maybe another 30 plus more. This winter, a very normal winter, but a harsh winter, we had over 500,000 deliveries propane to customers in the state of New Hampshire. We think any home that does not get fuel and runs out is horrifically bad. Consumers have a choice. They can switch to other dealers. And we would ask you, if you're going to move forward, with some of these provisions that the remaining dealers in New Hampshire don't like, that you focus your energy on the 4 companies that are causing the problem. I will say that we worked with the Attorney General's office. We had a couple of meetings with them. The second one, we brought in 6 dealers, I believe, to try to get common ground. And we did get common ground on a bunch of areas. And I'm going to ask Ms. Anderson to go over that with you. But it's just really important that you all understand that all these retail propane dealers, and it mentions oil here too, in the state of New Hampshire, really, really, really take care of their customers. I would tell you that zero complaints speaks to that, okay? Outside of those 4 national carriers, they're run different. Therefore, you have some issues. So I would like Leslie to go over the differences in the amendment we're looking for versus what this bill has. And then I would ask, we have 2 dealers with us here today, that if you have any technical questions, I would ask you to say, if you don't mind saving them for them, unless Leslie or I can answer them. So thank you, Mr. Chairman. Leslie.
Thank you, Bob. Good morning. My name's Leslie Anderson. I'm the president of the Propane Gas Association of New England. We represent the 6 New England states, and our office is here in Epsom, just outside of Concord. We take calls that come in they go to Consumer Protection. They refer them to our office, and we spend a lot of time this winter helping people that were referred to that office to get heat. I have contacts higher up at all of these companies. Even the one on the list, Suburban, is not a member of ours, but the others are all members of ours. And any of those calls that came in, we were able to get deliveries in a fast amount of time, either that day or the next day, to those customers. As Bob said, there's over 500,000 deliveries that take place in New Hampshire. And we believe that the changes in Senator Reardon's amendment to this address the areas where we have commonality with the AG's office. You heard them speak to them. We've had complaints over the years about how long it's taken to pick up above-ground storage tanks. This bill addresses that through 30 days for a tank pickup fee. That's a whole new section we've added. We added a new section that talks about fees, makes the fees more transparent, so they have to be written. And if you change fees as a company, you have to send it and give your customer 60 days to agree to those fees. And it prevents the end of contract charges, the tank pickup fees and tank pump out fees after an above ground tank has been on property for 2 years or an underground for 5 years. And it also requires reimbursement for product in the tank. So that should make competition even stronger here in New Hampshire. We have 59 propane companies. 55 of those agreed to these changes and were willing to move forward. The ones that didn't are the ones that you see on that list before you that was shared with you. So we believe that this will cause the complaints in New Hampshire to decrease if these changes are put together. We're adamantly opposed to the emergency delivery provision. The problem that happens is when it gets cold or a storm starts to come, a lot of people panic and they call their propane providers. And this would provide another avenue for them to panic, say that they are at a certain level, and then the company has to stop everything they're doing and figure out what that customer is at for a level, and then address it. And we took hundreds of calls, daily during different times of this winter at our offices. And I'm going to stop my comments there and if you will, let you hear from Tom Manson, who is the CEO of Eastern Propane, one of our family-owned New Hampshire companies that is as big as any of the companies on that list that you saw in terms of the number of consumers that they have here in New Hampshire. And then also, I'd like you to hear from Rob Stanger from Simple Energy. He has a medium-sized company, about 100 employees out in the western side of the state. And I think the 2 of them can better address this emergency provision section and why we are so adamantly opposed to it.
Okay. Yes, of course.
If you could just indulge me with one question before that. I heard you say there was over 500,000 deliveries to New Hampshire customers this last year. When they were referred to your office by companies or the AG's office, or who refers them to you?
We get calls from consumers and they say that they've been given our number from the Consumer Protection or the AG's office. And when we take those calls, I have a staff of two ladies that help me to answer the phone. We immediately get those out to somebody high up at a company and get those resolved if they have been an issue. And there were more this year. We had a colder winter than we've had in 11 years here in New Hampshire. And we had sustained cold back to back. We had a lot of people that were using heat pumps that didn't use them this year, and they relied more on their propane system, so we had increased demand. So it was an interesting winter to have a winter again here in New Hampshire. And so our complaints were higher than they've been in the past. But I think it's a good wake-up call for us. We're definitely working with these people that had the complaints and talking with their upper management about how we can do better next year. We don't want anyone to go without propane in the state.
And if I may.
Of course.
And I did look at the list here. All of them are the four big one, with the exception of 5 complaints out of this list, and they were all the same company. So one of the smaller New Hampshire owned companies. And let me just clarify, when you got calls, everybody that you fielded a call from got propane within a day after you?
Within 3 days, to be
Within 3
sure.
days.
Some of the calls were, I would reach out to the company, and I would tell you that over half, probably 60 to 70% of those calls, they were not out of propane. The calls that came in, they were consumed. They would follow back up with me and say, oh, they had 30% in their tank. Or, oh, this is a consumer we've gone to 3 times, but we can't get down their driveway because they haven't plowed it. And it would not be safe for us to put our truck down their driveway to make that delivery. So we had issues with access to the consumer's location. And we also had many consumers that panicked and were saying that they were lower than they actually were. And that causes a lot of problems. They have to divert a truck, it's off delivery. And when we are having a winter like we had this year, we're operating at 110% capacity to get to everybody so that we can keep their tanks full. So it's very disruptive when you have the ability for consumers to cry wolf and not be honest about what they have in their tanks.
Senator Murphy.
Thank you. When you have a consumer who doesn't live up to their end of the contract and doesn't plow their driveway, for example, or something about the environment does not allow the delivery to be made, there's some sort of documentation, right? You take a photo, there's some evidence of the situation where it's then communicated back to the customer.
Yes, so if they can't get down the driveway for access, which happens quite frequently in the wintertime, when people haven't plowed or haven't, sometimes we can't physically get to the tank once we get there because there's so much snow or it hasn't been shoveled out. Then the company will communicate, they'll call and say, we couldn't make your delivery today because your driveway was impassable, and call us back and let us know when we can get in, to make that delivery. And so they'll document that in their computer system, or some of them might take a picture. Not everybody takes a picture, but that does happen more and more these days where it's documented. But it'll be documented by the company when that happens, if it's impassable. Or if there's a safety issue, there might be an issue where they get there and the consumer has added some equipment or done something, and we need to do a leak check before we can fill the tank, in which case the company will send information to, call the consumer, let them know, schedule for when we can get someone out there to do the safety check that's required before we move on. So those are the types of situations where it might be impossible for us to get in and make a delivery.
Thank you. One more question. Those conditions upon the consumer, those scenarios, they're spelled out in the contract they sign.
If there's a written contract, they are spelled out in the contract. We believe that those are force majeure events that happen. And so there are clauses in the different contracts for that. But we also think it's important to have that language in this statute, because if you don't have a contract, and many people are on automatic delivery and they don't have a written contract in place, that's fairly common for our consumers to do that. If they don't have a written contract, the company might have terms of service posted that have that information, or they would let the consumer know if it was impossible for us to deliver. If it's a a guaranteed price plan or a paid contract, those would absolutely be in writing. On the whole, most of our companies have written contracts, but there are many small companies that have just put people on automatic delivery, and they send them their terms of service, and they don't have a written signed contract in place between them.
Any other questions? All right, thank you both.
Mr. Chairman, could I feel this come up together?
Yeah. Sure. While they're coming up, I know some of you may be wondering about executive session today. Given the timing of things, I don't think that will be happening. I can pretty much assure you there will not be an executive session and we will not be voting anything out today. Aaron and I try to figure these out in terms of timing and we missed on this one. So it's, yes, sir. I would love that if you could do that. There you go. There's remarks. Thank you. All right. And I'm getting a lift from Senator Murphy over at Granite Place. So thank you, Senator, for that. Welcome, gentlemen.
Thank you.
Good to see you.
Good morning, Senators. Let's do introductions first. I guess we came here so we could put a face on the propane industry. As Leslie mentioned, I'm Tom Manson. I'm CEO of Eastern Propane. We're headquartered in Rochester, New Hampshire. We have 8 locations in New Hampshire. Rob?
Rob Stenger. I'm the CEO and owner of Simple Energy Partners. We are headquartered in West Lebanon, New Hampshire, and a portion of our business is conducted on the dark side of the Connecticut River in the state of Vermont.
Relative to the 4 companies that have really been the subject of the concerns, I'm not sure how I'd describe our company or Rob's company other than medium. We're not that big. We're family owned. Rob's company is privately owned as well. We've been around since 1932. The family is still involved. And I'd also, Attorney Stewart said she thought the majority of the propane delivered here in New Hampshire came out of those 4 companies. I don't have the numbers in front of me, but I suspect that's not true. At one point, it might have been true based upon the aggregate of the companies that those companies bought up. But we have a wonderfully competitive industry. If you screw up, if you fail your customer, they're going to go to somewhere else. And since we always tell our people, the only reason customers leave Eastern is if we don't do our job right. And believe me, we take that job extremely seriously. Attorney Stewart's right. It is a position of trust and responsibility, and we take that very seriously. And every one of our employees takes that very seriously. On the wall of every one of our locations, it tells us what we need to be for each customer: reliable, responsible, safe, and convenient. Reliable and responsible is all about getting out there before the customer needs fuel. And if there's a problem, responding to it. And that's who we are, and that's what we do. Now, we can go 2 ways here, depending upon what your senator's wishes are. Rob and I have a statement that we can go through that really, we support the large majority of what came over from the House, with the exception of 2 provisions. The emergency delivery provision, which we think is frankly inoperable and ultimately ineffective from the customer's point of view. It's not going to cure a thing. And we think there needs to be a force majeure, because the reality is we operate out in the big, wide, real world with cold weather and storms and supply issues. And if we don't show up, it's not because we're not trying. It's because there's been something that has happened beyond our control. All that being said, we are not infallible. There are times when we screw up, but we deal with it and get to the customer. The customer always does have a choice. We can figure it out and fix it. But I don't think that emergency delivery provision does one whit of good to fixing that problem. So I guess I'd ask you what your preference is. I know you have a concern of time. We can answer questions directly, or I can just go through this relatively brief statement with Rob, and we can give you our reasons why we don't think that provision is necessary.
Senator Murphy, do you have questions? Why don't we let you go ahead with your statement? And we'll
Oh,
take it
boy.
from there.
You notice I have a legal pad, which I have no idea how I ended up with, but
You got this.
yeah, sure.
Hey, we're reasonably casual. here,
Okay,
so,
well, and I have
yeah.
to read my own handwriting, Senator, which is the big problem
Feel free
here.
to summarize it
Yeah,
if you'd
okay.
like.
So what we do support, I believe, is Senator Reardon's amendment without the emergency provision and the force majeure provision. The emergency delivery provision included in the House version is really unworkable for New Hampshire companies like Eastern. And frankly, I don't think it will help at all customers who do not get a propane or heating oil delivery from their supplier when they needed it. Why? Because there are safety, operational, and practical issues with the provision. First, I want to address this provision from the perspective of the customer who needs a fuel delivery. For a heating oil customer, this provision is unnecessary. Heating oil customers own their own tanks. If their current supplier is not delivering as promised, then they can call another oil dealer for a delivery. The customer will find another company to make a delivery, but if demand is very high, it may not be immediate. If they called Eastern and we have capacity, we would help them out, but we would require an inspection of their oil tank by Eastern before we delivered. We want to make sure it is safe to put oil in that tank before we would deliver. And throughout this presentation, you'll notice that safety is a big concern in our fuel delivery industry. For a propane customer, this provision is not going to solve the problem. First, just saying the dealer has to deliver within 5 calendar days from the consumer's request or face an unfair business practices charge is not going to fix the supply, the operational, or other issues that resulted in no delivery. Then the customer is left with getting that dealer to provide written authorization to another dealer to make a delivery. Well, if the customer can't get a hold of their dealer to make a delivery, how likely is it they will get a hold of them to issue one of these written authorizations? My understanding is the problem dealers were not answering their customer calls in many cases. If the customer does get the written authorization, I think they're going to have a hard time getting another supplier to make a one-time delivery. That's just not how our business is structured or how we operate. Not because we don't want to help them, but because we need to take care of our own customers first, and that is a challenge enough during times of high demand. Our industry is really not structured for making these one-off deliveries. That is not how we operate. First off, there are safety issues. Before every first delivery to a new customer, Eastern performs a comprehensive gas check for safety reasons. And Rob, can you just go through that and why we do that?
I can, thanks, Tom, and I'll go relatively quickly, and prior to that, let me provide a little color. Simple Energy, the company that I own in West Lebanon, had over 100,000 customer contacts this heating season. We made over 45,000 propane deliveries, and countless times, I would put the number well ahead of 100. We deployed our logistics team to plow and sand driveways that would otherwise be unsafe for our service technicians or delivery drivers to negotiate. Well, we oftentimes do that at no charge to our customers. I also want to add that it's inexcusable. As a 33-year veteran of the propane gas industry, it is inexcusable that a company would fail so miserably to take care of its consumers that we would find ourselves here trying to legislate our way out of it. I also want to add, before I go through this punch list of the mandatory safety checks on any propane system, that twice in my career, I've worked with the New Hampshire State Fire Marshal's office where individuals had been killed in propane gas explosions. So I find it a little bit alarming that the State Fire Marshal's office doesn't see any profound safety concerns here. I can tell you from a very deep history in propane safety and working with accidents and accident investigation that there is a real safety concern, and that the performance of the safety performance of propane companies operating in New Hampshire should not overshadow the necessity for propane safety. That said, to Tom's point, anytime we acquire a new propane customer, we follow, and it's a nationally published guideline called Gas Check. Gas Check embodies the legal and moral obligation of duty to warn when delivering and servicing hazardous materials such as propane gas. The steps necessary in that process include, and I'm going to move fairly quickly here, first of all, the inspection, the tank has to be inspected. This is part of a chain of custody inspection. We have to make sure the integrity of the tank is proper. That includes where the tank came from, when it was installed, who it was installed by, and there are devices that we use to test the integrity, particularly with underground storage tanks. once the credit risk is satisfied, an asset ownership determined or the chain of custody determined and then transferred, an underground tank, which is regulated, has to be tested cathodically to make sure that
Mind
there's.
if I stop you there? No, not at all. So what I'm hearing from the two of you is that if my tank goes dry or it doesn't have propane, and I call a different supplier, I've got to go through a series of steps before I get that emergency delivery. Is that right?
We certainly should, yes.
Right.
Yes.
So it could be another week before I'd get an actual delivery from a different supplier. Is that an accurate statement or no?
I think it's going to vary by supplier, but I have 3 pages here of the steps.
Yeah.
And these are steps that include not just the vessel, the tank,
Right.
but the entire gas distribution system and every appliance, valve, and fitting attached to it. We accept the responsibility and liability
Right.
of the homeowner safety before we introduce propane gas to that tank. So it's a
Right.
comprehensive process.
So you're going to ensure that everything is adequate before you'll deliver that propane.
We must.
Would it be likely that my supplier, and I won't tell you who it is, but let's say I ran out and I call my supplier and they say, well, we can't get to you for a few days, right? My guess is they're going to get to me though. Even one of the big four.
I would.
If it were one of, right, okay.
We would too.
And I'd probably get it faster than I would if I'm switching a supplier.
Yes.
Yeah.
I think that's all I needed to know.
It's just not how our industry is structured,
I
Senator.
understand,
And
yeah.
there's good reasons for that. The concept of a one-off delivery in
Yeah.
the propane industry doesn't
not.
exist.
Yeah, okay.
It does not exist.
All right, and Senator Reardon's amendment, you're comfortable with those changes?
Yeah, with the emergency delivery provision out and the force majeure in.
Yes.
And I know there are concerns about the force majeure, but that's not going to remove.
Yeah, I
It's
understand.
Very, very rare.
the reality is there are force majeures every day we do our job,
Yeah.
whether it's the driveway isn't plowed
Yeah.
or whatever. It's just the
Understood.
reality of it.
Yeah, my spouse delivers for the postal service, same sort of thing, right? I
Yeah.
can't get to your mailbox, you don't get mail.
Exactly.
Yeah, yeah,
So-
okay. All right. Anything else you want to add?
And I don't think so, but a context as well. So during this winter,
I understand.
our customer service representatives, I know she had 171 contacts. Ours had 276,000 contacts. We're getting it right the vast majority of the time.
Well, if you think about 500,000 deliveries and 171 complaints,
Yeah.
uh,
And I mean, we did over 200,000 deliveries in New Hampshire.
Right.
The vast majority of our industry is getting this right.
okay,
Legislation is not going to fix what I believe are fundamental business management problems with the 4 companies that had problems.
Okay.
That's the issue. So
very, very good. Nothing further?
I don't think so, Senator.
All right. Thank you for your testimony. I appreciate it. Any questions? All right. Very good. Thank you. Is there anyone else who would like to speak on House Bill 1262? Seeing none, we'll close that hearing and we will very shortly commence House Bill 1630. I apologize for the delay, but that was important testimony. They seem to be and mine is the number one jumper. I didn't want to, but some guys didn't have tanks during COVID. Okay. That'd be great. Yes, yes. Thank you so much. Okay, so. Okay. Is the prime? Yes. Murphy? All right, we're going to open the hearing on House Bill 1630. I'd like to welcome the prime sponsor, Representative Murphy. Good morning to you.
Good morning. Morning, Chairman Innocent, honorable members of the committee. I'm Representative Nancy Murphy, proudly representing the citizens of Hillsborough 12, the town of Merrimack. I'm here today to introduce HB 1630 relative to prohibiting the sale of nitrous oxide. As you may already know, nitrous oxide is a widely accessible recreational inhalant that induces rapid euphoric and hallucinogenic effects. Once thought by users to be harmless, nitrous oxide can cause severe neurologic, cardiovascular, and psychiatric signs and symptoms with repeated use. This bill does not address use or possession. It's focused solely on sales. And it was amended in House Commerce to utilize liquor licensing as the most appropriate means of enforcement. With the support of various stakeholders, the New Hampshire Chiefs of Police, House Commerce Chair Hunt, and the assistance of Liquor Commissioner Chief Armaganian, HB 1630 comes to the Senate on consent for both House Committee and the full House. HB 1630 was drafted at constituent request by parents whose son became heavily involved in the misuse of nitrous oxide. They are here today to share their story, and I would ask if possible that they be allowed, following my testimony, to testify together. I shared an investigative journalism piece with the committee by email yesterday that provided a bit of insight into nitrous oxide misuse in our state. The subject of that piece is also present today and prepared to provide compelling testimony and answer questions as to her experience and perspective. I've provided hard copies of the medical testimony relative to this bill that the Director of Nursing of an inpatient medical detox facility here in New Hampshire also provided by email. The collective testimony of those who will follow me and from whom I have written testimony from you will provide more specifics about nitrous oxide, the life and health impacts of these using these toxic vapors for effect, the accessibility and ease of purchase of these inhalants despite the statutes that we have in place, and the need for improved regulation, enforcement, and accountability. HB 1630 would make the toxic inhalants addressed in this bill less accessible to those who would seek to misuse them, while ensuring availability for necessary use in industries that use nitrous in safe, non-recreational ways. If passed, this bill will act as a powerful deterrent for those who might think about selling inhalants for recreational use. It will hold accountable those who will choose to sell those inhalants unlawfully, and it will increase the penalty from what is currently in statute for doing so, and ultimately prevent incidents of youthful misuse from becoming life-threatening compulsion. I serve in the Governor's Special Task Force on Highway Safety, along with bill co-sponsor Senator Fenton. As was made evident in the video segment that I forwarded and some of the handouts that I've provided, passing this bill will address one of the governor's priority focuses, increasing public safety on our roadways by preventing impaired driving and reducing traffic accidents, injuries, and fatalities caused by drug impairment. I thank you for your time and attention and ask that you please consider this favorably and vote OTP. Thank you.
Okay, thank you, Representative. All right, seeing no questions, appreciate your testimony.
Thank you.
Now, there's some folks that like to testify together. I trust it's the three folks from Merrimack. Is it all, just two? Okay. So I have Brian Levesque from the Merrimack Police Department. So we'll bring you up first, sir, and then we'll come to you. All right. Good morning.
Morning. Good morning, members of the committee. My name is Brian Levesque. I serve as Chief of Police for the Merrimack Police Department. The testimony I'm going to be offering was prepared by our Prevention Enforcement Treatment Officer, who had testified on the legislative side of things. He's currently at a national conference for substance use disorder, so that's why. Okay. Nitrous oxide laughing gas. It's used when you visit the dentist. It's used to pressurize whipped cream. It's used to go fast in race cars. There are a number of legitimate purposes for nitrous oxide. However, walking in almost any smoke shop and even some gas station, you will see bottles of nitrous oxide for sale, ranging from small cans the size of a roll of quarters to large bottles close to the size of 2-liter soda bottles. The bottles are often painted in bright colors with colorful designs on them, and many times you'll see them with scented mouthpieces. for sale next to them designed to change the scent of things like pineapple, blueberry, raspberry, vanilla, mango, or 100 other scents. Much like we've seen with nicotine vapes, which is interesting because I've never been offered a flavor of nitrous oxide when I go to the dentist. I'm pretty sure if I add nitrous oxide to a 1971 Chevelle, it would not care what kind of flavor it was. But that's not what these nitrous oxide bottles are being sold for. They're being sold to be purchased by individuals who are going to use them to inhale the nitrous oxide to get high. When inhaled, nitrous oxide causes a very short, rapid, euphoric, and hallucinogenic effect. Because the effects are so short-lived, typically disappearing within minutes, they are often thought to be harmless. However, because of the short-lived effects, it often leads to repeated exposure and use, which can cause nitrous oxide to replace oxygen in the lungs, result in asphyxiation, lead to the brain damage. In 2013, the CDC reported 37 deaths involving nitrous oxide poisoning. In 2023, that number was 156, which equates to roughly a 450% increase in deaths involving nitrous oxide. The fact of the matter is nitrous oxide abuse is a quickly growing trend. Rates of abuse are aggressively on the rise nationwide and should be a concern of everyone in this room, and here's why. Nitrous oxide is most commonly abused by teenagers and young adults. Most statistics find that ages 14 to 22 are by far the largest demographic to abuse nitrous oxide. We know the adolescent brain is not fully developed until approximately 26 years old. That means the nitrous oxide is most commonly abused by those whose brains are still in development. This is due to a number of factors, including cost, the misconception that it's relatively safe, the ease of access, and the fact that it's seen as a legal option to get high. However, the medical data surrounding nitrous oxide abuse tells a different story. Frequent or chronic use can lead to disabling brain injuries, spinal cord degradation due to B12 deficiency created by nitrous oxide. Nitrous oxide abuse has been linked to memory loss, B12 depletion, brain and nerve damage, paralysis, depression, psychological dependence, and more. Increasingly, medical data is showing long-term brain damage is caused by use of nitrous oxide. Because the psychological dependence causes withdrawals, which are known to cause anger outbursts, dopamine imbalances, anxiety, and irritability. This leads to a long, difficult recovery road, just like any other addiction. It's often unsuccessful, requiring a large amount. Further, as nitrous oxide addictions continue, people grow tolerance to the inhalant, requiring a larger amount to feel the same effect and to negate the withdrawals. With this, addiction becomes increasingly expensive. When the addiction is no longer affordable, it can cause people to look for another cheaper street drugs in its place, running the risk of sending people down a dangerous road of further addiction. I've heard some people who feel this bill is redundant due to the fact that we have RSA 644.5, inhaling toxic vapors for effect. However, 644.5 refers to the action of inhaling. It does nothing to regulate the sale of known gas that is commonly abused by teenagers and young adults. This bill is a step in the right direction of limiting the ease of access to widely abused substance. A couple of months ago, Officer Agras went to all the smoke shops in the town of Merrimack to see who was selling what products and what, if any, restrictions they had on these products. One of the specific products he was looking for was nitrous oxide. He found it was sold in almost all of our smoke shops, several at our gas stations, and the bottle ranged from a small bottle for a couple bucks to a large bottle for $200. He even found one smoke shop next to a nice display of shiny, bright nitrous oxide bottles was a couple dusty-looking boxes containing whipped cream dispensers. He asked the clerk about the dispensers, and he acknowledged that they were there for sale, but it was not usually with nitrous oxide. He'd actually never seen anyone buy a dispenser. But I ask you this, if you want to make your own whipped cream, what comes to mind as a place to go to purchase the necessary items? I would venture to say it's not a gas station or a smoke shop. These items are being sold at these locations, not for dentists or automotive enthusiasts or the home baker. They are being sold at these locations to inhale. Further, all the shops he went to gave different ideas on who they could sell to. This bill would not be the end-all to preventing folks from obtaining nitrous oxide for legal or illegal use, but is an important step in protecting our youth from having easy, in-your-face access to a highly abused substance. So therefore, I support this bill, and the New Hampshire Association of Chiefs of Police also support this bill.
Okay, thank you for your testimony. I learned something there. It's interesting. Question, Senator Birdsell.
Thank you, Mr. Chair. Thank you for taking my question. Do we know where any of these are manufactured, or is there one particular area that manufactures these?
I do not know that, sorry. I just know they're present in almost all of our gas stations and smoke shops, so.
Thank you.
Okay. All right, thank you for your testimony, appreciate it. Peter and Kathy Albert, good morning and welcome.
Morning.
Good morning.
Thanks for taking the time to hear us.
Absolutely. Thanks for being here.
I'm Kathy Albert, my husband Peter, and we're here to talk about our son. We have a wonderful son. He's a chemical engineer. He's smart, has a great job, and always has a smile on his face. We noticed about April of 2025 that he was changing. He was becoming more reclusive and cutting himself off from our family. We later learned through a friend of his, God bless him, who was concerned for his health, that Steve was abusing nitrous oxide. What started out as a way to relax for him and control his anxiety quickly turned into an addiction. Like many of you,
A couple of us, yeah.
both of you, we knew little about nitrous oxide, but we quickly learned how deadly and addictive it is, and also how expensive. In a matter of 4 to 5 months, our son spent over $25,000 to fuel his habit. He cleaned out his entire savings account and maxed out his credit cards. The savings account was money he had been saving to purchase a home. Nitrous oxide does have legitimate uses in medicine and the food processing industries, but nitrous oxide is also sold in vape shops, adorned with colorful graphics, appealing names, and fruity flavor additives. The fact that it was so readily available in smoke shops all around town totally convinced our son that it was harmless. Finally, our son agreed to go to a treatment facility. At one point, he quickly left one facility and went back to his apartment without our knowledge. Pete and I went over to move his belongings out and found him actually inhaling with a balloon and canister in hand. Thankfully, he did go back to rehab. But when we went to move him out of his apartment, we found over 200 or more of the empty nitrous oxide canisters, the large ones. And I'll pass this photo around. After 4 attempts at residential treatment, the last attempt is so far holding. But we walk on thin ice every day worrying about a relapse. It is so easy to purchase nitrous oxide without any regard to life or health. We are here because we don't want any other parent or loved one to endure the helplessness and worry that we're going through. Nitrous oxide is highly addictive and dangerous and should be regulated. Please pass this bill.
Okay. I just, we have 5 children. I'm a retired police officer, 40 years law enforcement experience. And over those years, I'd seen all manner of drugs, drug abuse, drug usage. And I preached to our kids about the dangers of them, but never once did I talk to them about nitrous oxide. I wasn't aware of it until our son became addicted to it. I never knew it could happen to a 30-year-old engineer, but it did. And he spent a lot of time, he changed over that period. A very bright man, began to lose his memory. His short-term memory was terrible. It affected our family greatly, his brothers and sisters, us. Rehab has helped him quite a bit. During this process, when I found out that he had been addicted to this, I found out at the store where he was purchasing it, making thousands of dollars worth of purchases. So I went to the store and I asked the clerk. I walked in and I could see the nitrous oxide canisters with their, as Kathy described, pretty candy-looking packages around them. And I asked him, if he knew my son. And he said, yeah, I do. I said, well, yeah, because you spent thousands of dollars here. I asked him if he would not sell to him anymore, knowing that he could go to other stores. But I asked this individual, and he kind of smirked at me and looked at me and said, hey, look, we sell it for this purpose, but if they use it for other things, then that's not our problem. That was pretty frustrating to hear. He obviously didn't care. It was about making a dollar, which is, unfortunately the case. So I just ask you all, we're here before you like we were at the House, just asking for your help. And I want to just say, I want to thank Senators Ricciardi, Abbas, and Fenton for supporting this bill at this time. So thank you.
All right. Thank you for your testimony. Questions? I'll just say addiction touches most families, and I'm really sorry you've had to go through this. It sounds like you're on the right side. So
I hope so.
God bless, and I hope it continues to go well. Thank you both. Appreciate it. Holly Hill. Good morning.
Good morning. I'm just going to read from something if that's okay. So, good morning. Thank you for taking the time to hear my story about nitrous oxide addiction and the severe consequences of its legal sale for recreational use. My name is Holly, and I was born and raised in New Hampshire. I have lived, grown, been a student, established a career, and worked to raise a family here my entire life. I love New Hampshire and the exceptional landscape we all call home. I'm here today to try and make it a safer place for other young and vulnerable members of our society by sharing my experience with you. 4 years ago this spring, I woke up in a psych ward for the first time, completely unaware of the severe drug-induced psychosis I had been in for days. My father had taken me to Concord Hospital for an involuntary admission after finding me stranded in a smoke shop parking lot where I had run out of gas, but still had been able to purchase 200 more nitrous cartridges and inhale them on site. Although parked that day, I often drove while doing nitrous without a balloon to reduce freezer burn and with reckless abandon for my safety or the safety of others. My rock bottom was lower than I ever imagined it could be. I truly didn't recognize myself. I had been seeing loved ones who weren't actually there, laughing without reason, hearing voices that didn't exist, and thinking paranoid thoughts I couldn't even imagine, let alone say out loud just 6 short months beforehand. And on that day in February, in depraved and delusional desperation, I had run out of gas in my car, alone and totally out of my mind, in the parking lot of a smoke shop that is less than 2 miles from here and is still in operation. They allowed me, their favorite nitrous addict, to leave my car in the parking lot until my twin came to move it 6 hours later. She said it was the saddest moment of her life because my car looked as destroyed as I was, filled with over 7,000 nitrous cartridges. Nothing else, no food or water or any other signs of a real life. Today, 4 years later, I can't help but look back at that time and wonder who that person was. Before nitrous, I was a mother, a librarian, a highly qualified educator, a mentor, friend, and daughter. During active addiction, I was nothing but nitrous. There is a before and after in my life. I know now that the allowance of this drug to be sold and purchased in any quantity at any time by any person was a huge contributing factor to my addiction. There were many days before and after this one in February that I walked into a New Hampshire smoke shop and bought hundreds of nitrous cartridges, multiple times a day, as I always told myself it was the last time that I wouldn't go back. Every day for months and months. I was never carded. I was never told no or was ever refused sale, even after purchasing hundreds a day from the same clerk. Looking back now, I know they saw me, broken, sick, and continually desperate for more drugs, but they, as individuals, had no recourse to refuse sale. They were stuck, and so was I. It wasn't until April of 2022, when I ran out of money and hope, that I was re-hospitalized for the final time. I'm fortunate my family was able to house me, care for me, and keep me in their sights for the next 6 months after I went through my final rehab, as I certainly would have relapsed. At the end, I could not walk, participate in basic discussions, form new memories, or even participate in daily chores. I was cognitively wounded, irreversibly, something I had not anticipated in my wildest nightmares. My physical, mental, and emotional health is still affected by the addiction I had to nitrous oxide to this day, and I recognize it's something I will never fully recover from. It is truly a miracle I am alive and never hurt or killed anyone else while I was in active addiction. I'm extremely grateful and thankful to be alive and be here today to support the regulation of nitrous oxide sales and hope it can be supported by lawmakers. I lost almost everything I had worked my entire adult life for and had spent over $26,000 in 6 months because of my addiction to nitrous oxide. Without unlimited access to this drug, first through Amazon and then in person at a variety of smoke shops simply between Laconia and Concord, I am certain I would not have fallen into the severe addiction I did. Coming forward with the story is painful, embarrassing, and leaves me feeling very vulnerable. But I know my story is unique as I survived. Most who become as addicted as I do not survive, and if they do, are paralyzed or neurologically disabled. It is important for me to make meaning from my experience and possibly help save a life. It is a miracle I'm alive today to share this with you, and it is my sincere hope that my story helps compel you to support this bill. Thank you for your time.
Thank you for your testimony. No questions. Thank you very much. Appreciate it. I'd note that the Liquor Commission enforcement folks are here in support of the bill, but did not indicate they wanted to speak. Is there anyone who would like to speak on this bill who hasn't been called? Please come forward.
Did sign a sheet, but it might have been left up there. I'll be very quick because I know you're behind and I have written testimony. For the record, my name is Kate Fry. I'm the Vice President of Advocacy at New Futures. In this role, we work extensively with policymakers, stakeholders, and partners to prevent and reduce alcohol and drug problems in the state. We support HB 1630 and we applaud the sponsor for bringing this important bill forward. This is one of a few bills you'll see this year that tries to address the issue of a continuing market of addictive products that are marketed to minors. Industries who sell addictive products, they found workarounds to continue to market these dangerous products to young people and people with substance use disorder, vulnerable populations. They rebrand, reformulate, and exploit technical definitions in the law. You'll see strategies like definition loopholes, unregulated products, deceptive marketing, regulatory gaps. Nitrous oxide kind of checks off all those categories. I won't repeat the statistics you heard earlier. I will say this is not a problem just solely happening in New Hampshire. It is happening across the country. Several states have taken action. I will bring you a document from the Network for Public Health that shows you the proposed or pending legislation. But we ask that you support this bill. We do have pictures as well from stores in New Hampshire that sell these products. We haven't indicated where, but it is a problem in New Hampshire, and we ask that you vote to support the bill.
Thank you. Question from Senator Birdsell, please.
Thank you, and thank you for taking my question. Right off the bat, do we know if Massachusetts is trying to do anything about it?
Not off the top of my head, but this document should give you that, and I can follow up with you as well. I believe there are over 30 states that are working on legislation to ban these products.
Okay.
So I can get that for you.
Do you think that if we ban them and Massachusetts doesn't, will that be a possibility of going over the border?
That certainly is a concern, especially when you distribute products regionally, and we have seen this with intoxicating hemp products as well, too. But this bill does give the enforcement to the New Hampshire Division of Liquor Enforcement that if they see these products, they can take action in New Hampshire.
Thank you.
All right. Thank you for your testimony. I don't normally make editorial comments, but this doesn't sound like it'd be fun at all. I mean, I just don't understand, but okay. All right. With that, I'm going to close the hearing on Senate Bill 1630, and we will open 1245 in a moment.
Morning, Mr. Chair, members of the committee. Good morning, Mr. Chair, members of the committee. For the record, my name is Brian Labrie, and I represent the town of Bedford Hillsborough, District 2. I'm here today to introduce House Bill 1245, the Voluntary Portable Benefit Act. Currently, New Hampshire's independent workforce is stuck in a binary trap. They can have the flexibility they want or the benefits they need, but rarely both. Our laws haven't kept pace with this shift in our workforce autonomy, and it's time we modernized. Right now, many small businesses want to keep their independent contractors or want to help their independent contractors with health and retirement costs as a perk of keeping them coming back, but their lawyers say no. They're afraid of providing a benefit will be used against them in a misclassification audit. We are effectively punishing businesses for being good actors. House Bill 1245 fixes this by creating a safe harbor. It allows benefits to become portable, meaning they belong to the worker rather than the company. Much like a commercial driver's license or professional certificate, these benefits would follow the worker from project to project. The mechanics of this are simple and entirely market-driven. An independent worker opens a personal benefit account with a third-party provider, and a company can add a benefit tip line to the contract with the worker. House Bill 1245 ensures these payments can't be used in court to trigger a change in employment status. This is the legal shield our small businesses need to stay competitive. This bill mandates nothing, creates no new taxes, and no new bureaucracy. It simply removes the legal barriers from preventing the private market from contributing to these benefit plans. Utah, Tennessee, and several other states have proven this model works with strong bipartisan support. If we want New Hampshire to remain a magnet for top talent, we must provide this legal certainty. With that, I'd be happy to take any questions if you have them.
All right, any questions? All right, thank you, Representative. Appreciate it very much. Cassie Abbott is here from the New Hampshire Department of Labor. And she would like to speak. Good morning.
Good morning and thank you. My name is Cassie Abbott. I'm the Department of Labor's legislative liaison. The department has reviewed this proposed bill. We are neutral on the bill. The department understands our role in this bill to be that we cannot consider the following actions when reviewing a worker's classification. That is offer of contribution to a portable benefit account by a hiring party, independent contractors' participation, and or control over such plan or account, and an administrative act of withholding or remitting contractor funds as authorized under RSA 283(8)(2). The department would like to note that we do not view ourselves as a dispute resolution venue. If a dispute arises between an independent contractor and a hiring party, as with any contract dispute, they would have to go to court to resolve the issue. The department understands the proposed language, and we believe we can follow the regulation, and I'm happy to take any questions.
Okay, very good. Senator Birdsell, no questions? All right.
Thank you so
very
much.
Jonathan Wolfson from the Institute for the American Worker. Good morning.
Good morning, for the record.
If you could turn your mic.
Pardon me.
There we go. Thank you.
Good morning, Jonathan Wolfson for the Institute for the American Worker. We're here also with Americans for Prosperity. Appreciate the opportunity to, Mr. Chairman and members of the committee, opportunity to come and testify in favor of HB 1245. The Institute for the American Worker is an advocacy organization that is a nonprofit headquartered in Washington, D.C. that works to try to allow workers to advance the benefits that they would like as workers. And one of those things that many workers would like is things like health savings accounts, flexible spending accounts that they get typically from employers. But independent workers, the 70 million independent workers around the United States, the about 120,000 or more New Hampshire residents who are themselves small business owners, independent contractors, those individuals have to pay extra in order to get those same sorts of benefits, in order to get access to them. And as the Department of Labor just mentioned, one of the challenges is that the attorney for a business that retains, say, a window washer at their restaurant, is that the restaurant attorneys will tell them, if you put dollars in someone's health savings account, then the Department of Labor, the Workers' Comp Board, or the courts might say that that person is in fact an employee. And all this bill does is provide a safe harbor that says if the worker and the business agree, and this is not something that can be forced on them, but if they agree that they would like dollars to be diverted into these sorts of portable benefits, into retirement accounts, into health savings accounts, into child flexible spending accounts, that is not going to be a factor in determining whether or not that worker is an independent contractor or an employee. And that's all this bill does. And so we support it. I'm happy to answer any questions or technical details that folks might have. Thanks so much.
All right, no questions. Thank
Thank
you,
you.
sir. And Sarah Scott from Americans for Prosperity. Also in support.
Thank you, Mr. Chair, for the opportunity to testify here today. My name is Sarah Scott, and I'm the Deputy State Director for Americans for Prosperity in New Hampshire. I'll keep it brief, seeing as you guys haven't had any questions so far. But Americans for Prosperity is here in support of this legislation. We think that self-employment pathways for workers really allow individuals to enjoy these flexible working arrangements. We found that independent contractors overall, while they're very happy being independent contractors, they're nearly 11% less likely to have health insurance than traditional employees. And the majority of those that do have health insurance only have it through a spouse. So we see this as an easy change to continue to allow these kinds of flexible working arrangements. The only thing I wanted to highlight is that a lot of other states have passed this legislation this year, but we would be the only state in New England as of now. I believe Connecticut is considering this, but Massachusetts has taken a step to have the Massachusetts Driver Portable Health Fund, which was went into effect last April as part of the settlement between the Attorney General and Uber and Lyft. So they are operating this program, but it's limited to a single industry and it's tied to specific companies. So I think this is a really good opportunity for New Hampshire to stand out and be a truly flexible working arrangement. And we can really take a more thoughtful approach to what we do here in New Hampshire. But overall, encourage you to support this legislation. Happy to take questions.
Thank you. I don't think so. Thank you very much. Appreciate it. Is there anyone else who would like to speak on House Bill 1245? Seeing none, we'll close the hearing. And I'll wait an extra minute this time. I think I'm getting ahead of staff a little bit. Next up will be House Bill 1406. Yes. Keith took it. He was going over for, I have an 1110. He had an 11, so he got me covered. I do have a 1210, but it looks like we'll be okay. Maybe. All right. Yes, please join us. And let me get to the right page in the big binder of bills. Okay. All right, we'll go ahead and open the hearing on House Bill 1406, and I'd welcome Representative Grink to introduce her bill. Good morning.
Thank you, Mr. Chairman and member of the committee. We're down to slim lines here. So for the record, I'm Alicia Gregg. I represent Hillsborough District 7, and I'm here to present House Bill 1406. Nationally, major health insurers are facing lawsuits because they're using AI systems that review insurance claims in as little as 1.2 seconds per claim. 1.2 seconds to review complex medical decisions. When these AI denials get appealed, 90% of them are overturned. That's not efficient technology making good decisions. That's a broken system automatically denying care that patients actually need, and patients having to go to court to get their medical coverage. What makes this particularly concerning is that AI systems can be shaped to produce specific outcomes. If an insurer wants to reduce costs, they can train the AI to find reasons to deny claims. In the House, we heard testimony from a software engineer who builds these systems for a Fortune 50 health insurer, and he explained that AI is essentially a sophisticated random number generator that can be programmed with whatever priorities the company chooses. I believe that he is here to testify today as well. AI also struggles with exactly the kinds of cases that need the most careful review, patients with complex long-term medical histories involving multiple diagnoses. A person who's been managing diabetes, heart disease, and kidney issues for years doesn't fit neatly into an algorithm. Their care requires a human who can understand the full context of their medical journey, not a system that sees isolated data points. This legislation builds on New Hampshire's existing strong patient protections by adding 3 AI-specific requirements.
First, when insurers use AI in claims processing, a qualified healthcare provider has to make the final decision on any denials or payment reductions. AI can assist and flag things for review, but a real human with medical training has to make that final call. Second, insurers have to tell patients and providers when AI was used in a decision, just basic transparency. And third, insurers have to keep detailed records about how they're using AI so the insurance department can actually audit what's happening. And downcoding might sound technical, but it has real impact. When AI automatically reduces payment for services that were actually provided and properly coded, it does two things. First, it takes money from providers who delivered the care their clinical judgment told them that was necessary. And second, it creates a chilling effect where providers have started coding conservatively to avoid AI downcoding, which means they're not accurately documenting the complexity of the care they're providing. After the House hearing, I worked closely with the insurance department to develop this amended approach. Rather than creating a whole new regulatory framework, we're adding AI-specific requirements to existing law that's already working. The department already has comprehensive protections in place for patients. This amendment just makes sure those same protections apply when AI is involved. We're also not alone in this. California, Arizona, Maryland, Nebraska, and Texas all enacted similar protections last year, and 19 other states are considering this legislation right now. We're joining a national movement to establish reasonable guardrails as this technology evolves. When it comes to denying or reducing healthcare claims, real doctors should make the final call, not algorithms. AI can be incredibly helpful for administrative tasks, catching fraud, and speeding up approvals, and we aren't prohibiting that kind of use at all. But when an insurer is going to tell a patient no, a qualified human needs to review that medical record and own that decision. I encourage you to pass this, and I'm happy to answer any questions.
All right. Thank you for introducing the bill. Any questions? All right. Thank you very much.
Thank you so much.
Appreciate it. The Insurance Department, Michelle Heaton and Josh Hilliard, to welcome you. Welcome back, Josh.
Good morning. My name is Michelle Heaton. I'm the Director of Life and Health at the New Hampshire Insurance Department. As the sponsor mentioned, we did help take the original concept and put together an amendment to address it in a way that's going to make sense for how we are already regulating these products. So just to give a little bit of background, artificial intelligence is something that we have been monitoring and regulating for some time now. The department a few years back issued a bulletin on artificial intelligence that lays out a framework for how we would go about reviewing and regulating it and put some guardrails for curious to understand what we're looking for as they start using artificial intelligence in different systems. We're also in the process right now of updating our utilization review rules. That's the INS 2000 series, as well as our claim processing rules. And this is specific to Major Med, and we have a whole new set of rules that are claim processing rules specifically for Major Med, and that's in INS 1003. Both of those rules are currently in rulemaking right now and do include provisions about artificial intelligence, some key definitions, and how we will be regulating artificial intelligence in the context of claims and utilization review. A lot of the work we're doing is piggybacking off of the NAIC model, and that's the bulletin we issued was a model bulletin issued by a number of other states. We're really trying to stay within the context of how NAIC is defining things, because that is a consistency among other states. What we don't want is for artificial intelligence to be defined one way in New Hampshire and a different way in some other states when we're all trying to look at the similar things. So that's where we really worked with the sponsor of this bill to try to take those concepts and put it into something that's already in place using those same definitions we've already been developing and that are already incorporated into some of the rulemaking we're actively in. So that's just a general summary of what we're trying to do. I think a lot of this amendment is just making sure that to the extent artificial intelligence is being used, there are appropriate records and documentation about how it's being used, who's making the decisions. One point of clarification is in In the context of utilization review, and those are your medical necessity determinations, whether certain care is appropriate, our laws have always required a person to make those decisions. This only makes it even more explicit that you cannot use artificial intelligence for that. And the way our managed care is set up, once that decision's made, there are appeals processes, there's external review. All of that is by medical professionals. We already have extensive regulations about who can make those decisions and parameters around those decisions. So that's our update. I'm happy to answer any questions.
All right. Questions? Senator Fenton.
Thank you, and thank you for taking my question. Under current law, are there any current gaps in how carriers disclose how they use AI that you have seen, especially when you're designing these national models or looking at these national models?
No, under our regulatory structure, we have very broad authority to basically ask an insurance carrier for anything. And that includes how they're using artificial intelligence and all the documentation that goes along with that. I think where there's a perception that there are gaps is that consumers aren't going to know the inner workings of how an insurance company works. It's difficult enough to teach consumers how to use their insurance policy, never mind the complexities of claim adjudication. So I can see why people would be interested in that, but I'm not really sure that that's going to advance anything. As the regulators, this is something we are actively looking at and something that has been part of our regulatory framework for a while now. And we're developing tools to better monitor that and make sure there's consistency among other states and across the country.
If I may, Senator, thank you. It is worth mentioning that the department is, of course, is in constant communication with the National Association of Insurance Commissioners, and there's a number of subcommittees that are dealing with these sorts of issues. So this is something that's very much on the radar, very much work in progress as we continue to refine and try to meet that best road that is going to provide for innovation, but also safeguarding consumers.
Quick follow-up. So just to clarify, you don't see any gaps?
Not currently under our system, no.
Yeah, thank you.
All right. Senator Birdsell.
Thank you. Thank you for taking my question. So do you perceive this as kind of a belt and suspender type piece of legislation where we already don't allow insurance company to use AI as a determination on denying claims?
Yes, that is the current structure. It doesn't explicitly say that in our statute, but the way the whole system is set up, that's not allowed currently. So it doesn't hurt to put some explicit language in the statute. And I think that is the purpose of this legislation, is to say explicitly, you can't do this. And if you're using AI, make sure you're keeping documentation of these specific things.
Thank you.
All right. Thank you very much. Appreciate your time this morning. The next speaker has the last name, I believe, Thompson. I can't read the first name. There we go. Good morning, sir. If you could turn on that mic and state your name.
Good morning, and it's Adam, and I've got some poor penmanship. My apologies.
I can see that now.
When I was teaching, it really bothered my students.
You should be a physician with that. All right.
Well, with the use of AI, no, I'm just joking. Good morning, my name is Adam Thompson. I'm from Nashua Scenic and Historic Ward 3, and I'm a disabled veteran. And I'd like to thank you guys, Mr. Chair, Senators, for the opportunity to speak in support of HB 1406. This bill takes, in my opinion, a thoughtful and practical approach to a rapidly evolving issue, the use of artificial intelligence in healthcare decision-making. As I mentioned earlier, I'm a disabled veteran and I work with many other disabled Granite Staters with complex medical conditions. One of my concerns with the use of artificial intelligence in the medical field is the possibility of an algorithm downcoding or changing my doctor's or care team's medical recommendations to something that would prioritize a bottom line over the health of the patient, myself or any of our constituents. As a healthcare end user, i.e. a patient, that is my concern. Rather than prohibiting the use of artificial intelligence outright, HB 1406 establishes clear guardrails within the New Hampshire's existing utilization review framework. It requires transparency in how AI is used, ensures documentation of its role in decision-making, and requires that adverse determinations be made by a qualified healthcare provider as opposed to artificial intelligence, which is an important factor in protecting our health. That means decisions that deny care, reduce payment, or change provider coding cannot be made solely by automated systems. It's an important balance. Artificial intelligence can be a very useful administrative tool. It can help process large volumes of information and improve efficiency. But clinical decisions are not purely data-driven. They rely on professional judgment, patient history, and context that cannot be fully captured by an algorithm. They also depend on the relationship between patients and their care teams. Providers who know the individual, understand their history, and can interpret needs in ways that extend beyond standardized inputs. This bill helps ensure that technology supports care without replacing individual medical judgment. Many people in our communities live with complex nonlinear conditions, often involving multiple diagnoses, overlapping needs, and evolving care plans. These realities don't always fit neatly into standardized systems. For many people with disabilities, chronic conditions, or neurodivergent profiles, care is rarely simple or predictable. Treatment may involve multiple diagnoses, overlapping meds, sensory consideration, communication differences, or nonlinear progress. People with atypical medical profiles are often the first to experience friction in rigid systems, making transparency and meaningful human oversight especially important. HB 1406 also strengthens accountability. It requires insurers to maintain records of how AI is used, to document the clinical basis for those decisions, and to remain responsible for the actions of any third-party vendor that they contract with. These provisions help ensure that complex systems remain accountable to the people they affect, with decisions that are transparent, reviewable, and grounded in identifiable clinical reasoning. These are reasonable, enforceable safeguards that build on existing law while addressing new technological realities. At its core, this bill reinforces a simple principle. When a patient's care is being evaluated, there should be a qualified human being and protections in place responsible for that decision. For these reasons, Mr. Chair, Senators, I respectfully urge you to pass 1406 as amended. I think that amendment also makes it a much stronger bill. So I appreciate your time. Thank you very much.
Thank you. Are there any questions?
Just a statement. Thank you for your service.
Oh, absolutely, Senator. Thank you.
Yes, thank you. All right, appreciate it. Andrew Horn.
Andrew Horn, I'm from Amherst.
All right, good morning.
Good morning. So, Chairman and members of the committee, thank you for hearing me. And thank you, Senator Birdsell, for co-sponsoring this legislation. I'm a software engineer who has worked inside 3 healthcare companies, including a Fortune 50 health insurer. I use AI daily, and I'm here to tell you we need this bill. Modern AI is built on random number generation, complex math that even its creators don't fully understand. It's an incomprehensible lottery. Trusting invisible mathematical probability with real human lives is like building on a house of sand. We cannot let medical decisions proceed from the machine alone, or we make the calculator king over human conscience. I've seen these companies from the inside. They hire developers at $50,000 a year to implement tools that PhDs barely understand. The people in charge are doctors and business managers, not technologists. That can be dangerous. We're not asking the machine to be silent. We're asking human beings to have the final word. This legislation provides that fix. It's better to tie the machine down with paperwork than to unleash it on our patients without constraints. A medical decision without a doctor's sign-off is like a ship without a captain. A qualified physician's signature must seal every verdict, or that verdict isn't valid. The bill also brings transparency. Documentation is how we shine a light on the decision-making process. What the algorithm creates has to be visible to humans, or it's not governance, it's gambling. Transparency is the oxygen of accountability. Without records, we suffocate. Finally, regarding contractors, if you delegate the decision, you still have to hold the chain of command. You can't outsource your conscience. The insurance company must stay responsible for what its contractors do. This protects patients, it protects doctors, and frankly, it protects the insurance companies from their own blind faith in technology that they don't understand. It protects them from the legal liability of the mistakes that the system might make. Let's pass this act. Let's keep medical decisions in New Hampshire where they belong, in human hands. And let's, do the same as what the House did unanimously. I also want to mention, we don't know what's coming, so it's important that we put this regulation in statutes right now. Thank you for your attention.
Okay, thank you, Mr. Horner. Any questions? Great, thank you. Appreciate it.
Thank you.
Sabrina Dunlap.
Good morning, Chair Innes and members of the committee. My name is Sabrina Dunlap. I'm Senior Director of Government Relations for Anthem Blue Cross Blue Shield. We are opposed to HB 1406 for a number of reasons. First, I want to be clear that we do not use AI to deny claims. Such decisions involving clinical judgment are, in fact, signed off by a human. We do, however, use AI to help speed up our systems for approval and to catch patterns of fraud, waste, and abuse, which cost the healthcare system billions every year. Our concern with the original bill was that it was so broad it would inadvertently prohibit such important and widely accepted uses of AI that save our healthcare system money. The language was amended and improved. We still have concerns with the breadth of some of the language, and I believe there is an amendment, a small amendment that could help further tighten the language. But I think this gets at the difficulty in trying to legislate such a dynamic and fast-moving area of technology. And I know it was mentioned already, the Insurance Department issued a bulletin in 2024, and it is quite robust. And they do already have the tools to regulate this area sufficiently. I just think something like this in statute can have adverse unintended consequences, and we think it's unnecessary in light of the Insurance Department's existing regulatory authority. I also would just note that providers use AI quite a bit. They use billing companies, electronic health record companies to find codes that maximize revenue. And this bill does nothing to regulate that issue. So in closing, I would say, I think this issue is better suited for regulations and the Insurance Department's existing authority, and we respectfully oppose this bill. So I'm happy to take any questions, and thank you for the opportunity to testify.
Thank you. Are there any questions? Senator Fenton.
Thank you for taking my question. Just being devil's advocate a little bit, is it fair to say AI can influence which claims may be reviewed and may not be reviewed?
Thank you for the question. I'm not sure I fully understand though.
So you said a human signs off at the end, no matter what. But is AI determining what humans taking a closer look at, what claim, or if that claim gets a closer eye from a human look, it's not being flagged appropriately, or maybe not routed to that human?
So my understanding of the way the systems work is that AI will be used to approve and move the process faster. But if there's a situation where a claim is denied, that claim will be reviewed and the decision will be made by a person.
Okay, just follow up if I may. But so reading through this bill and hearing what you have to say, my fear is that AI is very helpful, but things could be falling through the crack because we're relying on AI to flag something, when in reality, maybe a human look would actually be able to flag that versus a computer.
Okay. I'm trying to think of how to respond.
I'm spinning you around, sorry.
So the question is,
May AI influence if it does in fact get flagged or not?
does AI influence whether something gets flagged or not?
Cigna is following you. I wonder.
Yeah, and I don't want to be repetitive. I'm trying to think through how to answer that in a way that's helpful. All I know is that that AI doesn't change the process in terms of how we review claims that are not being approved. And so I think it is used to help things move along, but in the case where something is not going to be approved, where it will be denied, there is still, AI does not change that. So I think that's the best way I can answer it.
Thanks.
Sorry.
Appreciate it.
All right.
Okay.
Thank you.
All right. Thank you. All right, Cam, it's either Lapine. Yes, I think that's right. I never know. So good morning, sir. I think this is the first we've seen you all year in Commerce. Yes?
Good morning, Mr. Chairman, members of the committee. For the record, I'm Cam Lapine. I work at Warren Reno, here today representing Cigna. We are opposed to House Bill 1406. Being handed out to you is a letter of written testimony, which I will defer mostly to, as well as a copy of the Insurance Department's proposed 2000 series rules. I will flag for you section 2002.07, which is on page 13, which addresses AI. And then also a copy of the Insurance Department Bulletin 24011AB, which is the overarching AI bulletin that applies to all insurers. So I think that those two handouts speak to what you've heard already, that the Insurance Department already has the authority to regulate and oversee the use of AI by insurers. To Senator Fenton's question that you just raised to Sabrina about relying on AI to flag and how that, I think the answer is no, because all claims get reviewed. So I don't think that that would be an issue as you raised it. Senator Birdsell, to your question about is it belts and suspenders, I think if it were just belts and suspenders, I wouldn't be opposing this bill. This bill goes beyond belts and suspenders, however. There are a couple of portions of the bill, three, that go beyond what's already in regulation. Specifically, the crux of that would be on line 13 of the bill as amended by the House. The line reads, all adverse determinations, comma, including payment reductions and downcoding, comma. Adverse determinations is a defined phrase in statute in RSA. It's in my letter, RSA 420J3, and that involves the review of clinical materials for a determination of medical necessity. Payment reductions and downcoding aren't in our reading of it meeting that definition of adverse determination. So including them in that line is an expansion of the existing regulation and in conflict with the statutory definition of adverse determinations. We would consider those to be administrative functions. And so requiring by this bill a qualified healthcare provider to now be involved in those administrative functions would just increase costs and add delays to patient care for an administrative function. I will stop there and take any questions that you may have.
Any questions?
One. Thank you, Madam Chair. Cam, good to see you. Thank you for being here.
Senator. Thank you.
Just want to be clear, reading through this bill. So if AI is not used to deny or influence claims, then requiring this documentation and disclosure of its use would not change your current practices, correct?
So the addition of including payment reductions and downcoding, which is not an adverse determination, that is a change from current regulation. The rest of the documentation and whatnot it would be new to put it in statute, but it is a change in the bill to add including payment reductions and downcoding.
So just to follow up, if I may? So just to follow up, but if you were documenting the use of AI, it would not change your processes on denials or influence anything of that sort, correct?
I don't believe so.
Perfect, thank you.
All right.
Thank
You're
you.
up. Sorry, last speaker is Paula Rogers.
Good morning, Madam Chair and members of the committee. For the record, my name is Paula Rogers, and I'm here on behalf of America's Health Insurance Plans, AHIP. And I've listened to the testimony on this bill, which AHIP has issues with. And I thought Senator Fenton's question think it was his initial question where he said, are there gaps? Was a good question. Because I think there's a general anxiety that goes around insurance matters, and insurers and AI probably heighten that anxiety. So when the department got up and when Cam Lapine spoke, I was reminded of the fact there was a bulletin that the department issued, I think faster than probably other regulatory departments in the US, on AI. And the interesting thing I learned this morning, because I was not busy during that period of time in 2024, was that the department didn't advise the plans that the bulletin was being issued. So it was done within their purview without, which often happens with regulated entities, they sort of get in the mix early on. And I understand that in this instance, they didn't. So the bulletin came out advised as they were from their staff and probably at the NAIC level. And I think it's been an effective bulletin. That doesn't mean that things remain static and that there aren't issues. So this morning I spoke with Representative Gregg, and her main issue is this downcoding problem. And downcoding has a sort of negative tenor to it, but we can't forget that there is also, on the provider side, upcoding. So the balance between downcoding and upcoding, and it goes on either inadvertently and fortunately rarely advertently, it needs to be addressed. The codes that come in on a medical procedure, when the claims come in, they're processed rather mechanically. And I think when Cam Lapine was here, he was trying to get at that. It's sort of an administrative function. This bill would say that that administrative function requires a qualified health professional to be entrenched in that operation. And that's not realistic. So the question becomes, and Senator, I think you asked the question, and I'm not sure of the answer. You asked, well, what does AI do other than this routine stuff? What does it do? Does it pick up issues? And I assume if it's a competent algorithm and it's well programmed, it's probably going to be looking at coding trends that are problematic or irregular or something is amiss. So it's certainly a detective at some level. The question is, how far does that go down into an individual code? And does that mean that at that point in time, when that AI is doing what it does with its algorithmic prognostications, does a qualified health professional need to be lurking? And we would hope not. The question becomes then, so supposing there is a downcoding and a provider feels that this is wrong and they feel that they're being deprived of reimbursement or their patient is being deprived in some other way, there is an appeal process. And so the thing with this bill is basically that we would be comfortable with it, health plans would, if we just took out the reference to downcoding. Now, you say, well, there's an escape. Downcoding is not going to be properly supervised. Well, that brings into play a bulletin. That brings into play the regulation that the department is working on. That brings into play consumers and providers who have access to an appeal, and they also have access to a provider. And so my sense would be the department, hearing what's been said today, will be more attentive to what's going on in the community that they regulate. And I think most people are of goodwill, but I think New Hampshire would distinguish itself by passing that particular language on line 14, because I don't think any other state has done that boldly and directly. I think there have been perhaps 3 or 4 states, and as Representative Gregg pointed out, I think there are in as many as 18 states legislation is pending. I think that more should come out of this, but I think it's premature to move in the direction the bill does. So that's kind of what I have to say.
Follow-up? No? All right. Thank you for your testimony, Paula. Is there anyone here that would like to speak on House Bill 1406 but didn't have the opportunity? With that, I will close the hearing. Ray. All right, I am going to open the hearing on House Bill 1554 and the prime sponsor, Julie? Representative Miles, sorry.
Oh, forgot my glasses. Okay. Good morning, Madam Chair, committee members. Appreciate you having me here today. For the record, my name is Representative Julie Miles. I represent District 12, which is the town of Merrimack. I am here to introduce an improvement to our current peer-to-peer process. House Bill 1554 strengthens the integrity of our prior authorization procedures by ensuring when medical necessity is questioned, a treating clinician can speak directly with a qualified clinical peer. This bill is about making sure your doctor can speak for you. Current law references peer-to-peer review, but there are significant gaps that are currently remaining. Access may be cut off due to timing. The reviewing individual may not practice in the same specialty, and providers are not necessarily told who is actually reviewing their patient's care. These gaps create delays, frustration, and unnecessary denials. House Bill 1554 guarantees peer-to-peer access at any stage of the prior authorization, including after the appeal has been initiated. It requires the reviewer to be actively licensed, practicing in the same or similar field, and qualified to assess the service that's under review. It also requires disclosure of the reviewer's name, their licensure, the state it was issued from, and their NPI provider number, only to the consulting provider. The plans will state that peer-to-peer already exists. This is partially true. What often occurs in practice is that providers and patients are redirected into an external review or grievance process. That process is administrative, paperwork heavy, and is slow. It is especially burdensome for elderly patients and patients who are sick and going through a very difficult time in their life. They also may be dealing with emergency illnesses. You'll also hear from the plans that based on prior House testimony, they think there's a false belief that having your doctor speak with theirs on your behalf would ever make a difference in the determination. This is a specific attempt to drive patients into the external review process. It's almost like the plans are saying, fine, sue us, which is an option that so many lay people just don't have. They're already struggling with illness, they could be elderly, and they don't have the ability to pursue these options. It's remarkable that when peer-to-peer consult actually does occur, over 80% of those procedures and medications are approved. And this is the very reason the plans are trying to prevent it. Senator Ricciardi's work on SB 561 in the previous session was amazing and patient protective work. I think patients and we all thank her, and it was a good start. We do have a little bit of a gap to close. This bill does not change that prior authorization work. It doesn't mandate any approvals, and it doesn't duplicate any processes.
Appeals are administrative. A peer-to-peer review is a clinical discussion between a clinical reviewer and a consult. Early clinical dialogue often prevents prolonged appeals and ultimately reduces system-wide costs. HB 1554 is not redundant to current law, and it does not conflict with or undo any prior auth reforms that were passed in 561 in 2024. Rather, it complements that work by addressing who conducts the review, when it must be available, and how this transparency is ensured. Some opponents will argue that peer-to-peer review already exists in statute as a result of legislation passed in 2024, and that assertion is technically partial, but substantially false. SB 561 was a very important step forward. It requires carriers to offer peer-to-peer review and establish timelines around that process. However, the statute contains significant gaps that HB 1554 is designed to address. Under current law, access to peer-to-peer review can be cut off based on procedural timing, particularly once an appeal has been initiated. The reviewing individual does not need to practice in the same or similar specialty. They don't need to be actively practicing, and the treating provider is not entitled to know who is reviewing their patient's care. We are in the prior authorization process in the first place because the treating physician, the physician or clinician who knows the patient best, has already determined that this care is medically necessary. And when that judgment is overridden, patients deserve a timely and meaningful clinical conversation, not delay tactics and not administrative barriers. The changes made by the House were good ones. There were a couple of small technical changes, and by clarifying qualifications, timelines, and enforceability, House Bill 1554 aims to protect patients, respects clinicians, and promotes faster, more appropriate care decisions. Opposition to this bill will attempt to speak about unintended consequences and other frequently used buzzwords. The unintended consequences for the plans would be that more appeals would be approved and more care would be provided in a timely, efficient manner. This is what is best for caregivers and patient outcomes. I respectfully request the committee ought to pass House Bill 1554. And I'll take questions.
Thank you, Representative. Any questions? Seeing none, thank you.
Thank you.
Is Representative Nancy Murphy here? No? Okay. Sam Hawkins? Oh, I'm sorry. Insurance? Sorry. Michelle Heaton?
Thank you. For the record, my name is Michelle Heaton. I'm the Director of Life and Health at the New Hampshire Insurance Department. I just want to level set by telling you a little bit about utilization review and how it works and give you a little bit of a background of how this has been progressing. So the sponsor reference SB 561 that was passed a couple of years ago. It was effective as of January 1, 2025, and it made some substantial changes to prior authorization and how that was being conducted in New Hampshire. Prior authorization, in case you don't know, is where you would have to seek approval prior to getting treatment or access to an item or services. So it could be before you can get access to a drug or before you can have a procedure approved. It is used for many different things. Some of them are patient safety to ensure that the patient is receiving the appropriate care at the appropriate time in the appropriate setting, as well as a cost containment mechanism, so that if there are lower costs or more effective options available, those options are being tried first, as opposed to going to a more expensive or more invasive item or procedure. So that's why prior authorization is used. So going back a couple of years ago, there was a joint effort with bipartisan support and a work group that really looked at prior authorizations and ways we can improve it. And that is what was passed in SB 561. Since then, we are still in the process of implementing that. And as I mentioned previously, we are currently in rulemaking with respect to our utilization review rules. Those rules needed to be revamped to incorporate the changes of SB 561 with respect to prior authorization, but also it was a good time to update some of those provisions. We're also, part of that bill also included some data reporting, and that data reporting was just submitted as of April 1st. We are in the process of collecting that data, and it will be posted to our website very soon. And that data is carrier-specific metrics regarding prior auth, including timing, how many are approved, how many are denied. So that should be up on our website shortly. Just to go back and walk you through how prior authorization or any utilization review works is a person, we'll just use prior authorization because it's easier. A patient is looking to get access to say a service, a surgery or something. So their carrier will submit a prior authorization request outlining the reasons why this patient is a candidate for whatever the procedure is. The insurance carrier then reviews that and using their clinical guidelines will apply to make sure that that patient, based off of the records and what the provider has submitted, meets that criteria based on the clinical guidelines to approve that. Based on some preliminary metrics on that reporting that's going to be made public very soon, the majority of prior authorization requests, an overwhelming majority of them, are approved. However, sometimes they are denied. When they are denied, the carrier is required to put into writing the reason for the denial, citing the clinical guidelines and what specifically in the clinical guidelines is not met. Once the provider and the covered person receive that, they then have the ability to appeal that decision. When you appeal the decision, there's a brand new reviewer within the insurance company that looks at that request afresh. So they're looking at all of the reasoning, the appeal, the provider's reasoning why they think it's appropriate, all of the medical records, and they're re-reviewing it just to make sure. They then will either overturn that decision or uphold it. If it's overturned, then the person has access to whatever service or item they're looking to get, and that's essentially the end of the story. They would get whatever they need and continue on their way. If on appeal it is then denied again, now the person has the ability to go to external review. External review is where the same request is being submitted, but instead of someone within the insurance company reviewing it, it goes to an independent entity that we license and oversee. And that independent entity is looking at all of the information and will decide whether it is medically necessary or not. At that point, once there is that external review, that's the end of it. Both sides have to accept whatever the external review decision is, and there is no further appeal from that point. So in this entire process, there is a lot of due process allowed for the patient and for the provider to ensure that patients are receiving the necessary items and services they need. In this whole context, there are time limits, and if it's a standard, meaning that this is not, an imminent life-threatening issue, then when the prior auth is submitted, if it's done electronically, the carrier has 14 days to process that, and then if it's an appeal, they have 30 days to make a determination on the appeal, and then there are timelines for when an external review happens. If this is a life-threatening issue, or there's, it's going to drastically impact someone's life, they need immediate care, there are 72-hour timeframes for that. So you have to make that decision within 72 hours. They can appeal it, and that appeal needs to be processed within 72 hours because we don't want people sitting around waiting if it's potentially life-saving. Or something serious that they need access to, and they're going to have some kind of impairment if they don't have access to this. So that is the system that is currently set up. A lot of what SB 561 did is it put timeframes on that prior auth. So that is now that 14 days and 30 days if it's submitted non-electronically. It also included the data reporting. And with respect to peer-to-peer review, it expanded peer-to-peer review. So it used to be that you had to wait for that initial determination and then you could request peer-to-peer. What SB 561 did is say at any point up until you file that appeal, you can request peer-to-peer. And that is because a lot of providers like peer-to-peer. They want to be able to talk to a medical professional and say, this is why this is necessary for this patient. There are also cases that it's complex. There's a lot going on with the patient. It's more efficient rather than having to compile all that into, a very complex letter. It's easier to get on a phone and do a peer-to-peer. So in SB 561, we put in this requirement that they can request peer-to-peer at any point up until that time. And then the carrier would have to schedule that call within 2 business days of requesting peer-to-peer. So it puts some tight timeframes on that. So that is, in a nutshell, utilization review, kind of where we were, where we're going, and what's in the works. What this bill is looking to do is expand that peer-to-peer review so that even after that initial determination is made, it could be in the appeal process, it could be you're in at the external review stage. At any point in time, you can still request that peer-to-peer review. That's ultimately a decision for policymakers to make, whether you want to expand it to that. But it could have some unintended consequences of just some administrative burdens and some complexities in how that would actually work. Because if you recall, that initial determination is made by one person, and then if you appeal it, the laws now require the appellate reviewer to be someone completely different. And so depending on when you're requesting peer-to-peer, it could be, well, who are you talking to? And just the administrative tasks that will have to be undertaken to set this up to allow for this. There could be reasons why you would want to just go through the process to go to external review quicker than trying to get that peer-to-peer set up. So that would be some of the drawbacks to that, but ultimately it's up for the policymakers to figure out what you want to do there. So I'm happy to answer any questions.
Any questions? All right, thank you, Michelle. I am going to ask I hate to say for the rest of the speakers, we're going to need to empty this room for judiciary. So keep it quick. So Sam?
Hello. In that awkward time of day, I'm not sure to say good morning or good afternoon. Thank you for the opportunity to testify. For the record, my name is Sam Hawkins. I'm here today representing NAMI New Hampshire in support of House Bill 1554. I will be brief. I mainly want to talk about the experience of our community members that we represent in regards to prior authorization and utilization review process. Mental health care specifically is a space where we still see prior authorization requirements existing fairly commonly. These can be for certain medications, certain treatments at a higher level of care, or at times we can even see that prior authorization is still required for traditional psychotherapy. But for medications in particular, the right medication regimen finding the correct medication that works for the individual person can be a really long and challenging process. There are lots of small variations among psychiatric medications that interact differently with each patient, take time to start influencing their recovery, and it can be a really long road for a lot of people. To the extent that the prior authorization and utilization review delays this process for this patient, we can see that negative outcomes increase. People cycle in and out of hospitals, emergency rooms. There are impacts on their lives and the lives of their loved ones. While obviously the utilization review process is incredibly technical, to the extent that it can be smoothed out for the providers and for this patient experience, to help get these people into the treatment that they need without any burdensome delays really will improve their outcomes and their recovery in the long term. I have more information in my written testimony, but I'll leave that there for time. Thank you.
Thank you, Sam. Any questions?
Thank you very much.
Thank you. Sabrina? Again, just going to remind everybody to try and keep it quick.
Thank you, Chair Birdsell. and the committee. I will try to be very brief. My name is Sabrina Dunlap. I'm the Senior Director of Government Relations for Anthem Blue Cross Blue Shield. Thank you for the chance to speak. We are opposed to HB 1554 for a number of reasons. So just first, we think the bill is premature and unnecessary. Health insurance companies worked with a range of stakeholders, including providers, on a major bill to make thoughtful and meaningful reforms to prior auth in 2024. That process included input, expertise, and discussion from a range of stakeholders to arrive at a balanced reform to prior auth. Further, that bill only went into effect on 1/1/25, so it's only been in place for a year. Connected to that, as mentioned, the insurance department's working on rulemaking in this space. So it seems that timing-wise, it makes sense to at least see what we learn from that bill, since it's only been in place for 1 year, and let the process play out. And I won't go into details for the sake of time, but our read on the bill is it introduces new definitions around timing. The current law says that we have to do peer-to-peer within 5 days. This new bill introduces, the existing law is 2 days. The new bill introduces 5 days. It's a little unclear which one would be the governing timeframe. There's also changes to definitions around clinical peer, which we worked very hard on that definition. It follows industry norms and federal definitions already, and this bill would change that definition. So I will wrap there, but in closing, we think the bill is unnecessary and potentially complicates the existing law, which clearly provide for peer-to-peer review at the appropriate times. So thank you for the chance to speak. I'm happy to take any questions. Thank you.
Thank you, Senator Bertzel, member of the committee. For the record, I'm Cam Lapine. I work at Orin Reno. I represent Cigna. Here today in opposition to House Bill 1554. Getting handed out is a letter of written testimony as well as another copy of the Insurance Department's proposed INS 2000 rules. In this case, I direct your attention to page 13, INS 2002.08, which establishes regulations around peer-to-peer review. For the sake of time, I'm just going to point out that RSA 420J5 is the statute that governs grievance procedures, which is the appeal process. And J5 Roman 2 sets out the requirements of who can look at these appeals. And it requires, I'm going to read it because I want to make sure that this is clear. The review shall be conducted by or in consultation with a healthcare professional in the same or similar specialty who typically treats the medical condition, performs the procedure, or provides the treatment at issue in the appeal. So I just want to point out that there are requirements in statute that during the appeal, the person looking at the file, you're not sending someone with a gastrointestinal issue to a foot doctor, which was raised by a former speaker, a prior speaker. And at that point, I'll defer the rest to my written testimony unless you have questions that I can answer.